It's a great pleasure and honor to have been involved in this initiative and to have worked with Rico and Kabir over the last year or so to try and make it a reality. And this occasion, in that respect, is a real watershed. So my topic is settlement, and since I have about 1 minute before the interpreters disappear, very briefly, I regard settlement very broadly as a kind of preventative medicine approach to investment disputes. The worst thing that can happen is to really get them into investor-state arbitration, which is for all the reasons that have been already discussed. So the first step in the preventative medicine has already been laid out, and I think it's an important one, which is to be able to provide advice on investment claim proofing of domestic regulatory initiatives, and often that can be very easy. I mean, this is some of the most happy work that I've done in this area, which is to talk to governments and ministers about how they can tweak a regulatory initiative, often in fairly minor ways that will not affect achieving the regulatory objective, in order to avoid certain of the red flags that arbitrators might see. And again, often it's not as difficult as it might seem, and it's a lot cheaper than getting involved in any litigation process. Secondly, and this relates to work that I've done on MIGA and political risk insurance, there is a value, if one can do it, to having, at the stage at which the investment is negotiated or developed, some kind of assessment, social, environmental, perhaps more broad than that, that can often in advance, produce a set of red flags or pressure points that might down the road lead to an investment dispute, so that you can see up front what are the liabilities or risks. And, what kind of agency might do that? It's a good question. And I would note that, for example, UNCTAD provides advisory services to LDCs on a range of investment-related issues. So, there are various models out there of how one might do some kind of pre-screening or evaluation of the risks ex ante of particular kinds of large investment projects. Then when it comes to settlement itself, mediation has already been discussed, so fortunately that's been covered to some extent. I would only add that there's something that's lighter than mediation or less formalized, and that is reflected in a way in the role that the World Bank plays with respect to disputes or potential disputes that arise under MIGA contracts, which is kind of facilitation of more open discussion between the investor and the host state, sometimes bringing in a third party who understands the regulatory system and the government in that country, and also some of the needs, of the investor, can be very useful. And in this respect, international organizations, the UN, the World Bank, UNCTAD have some real advantages in that they work with governments and officials in the countries concerned all the time, and may understand aspects of the dispute and maybe ways of breaking a conflict or solving a conflict that wouldn't be evident to an investor, even if they have goodwill and the best lawyers in the world. So I think these are some of the ways in which we could think about settlement broadly in the way of facilitating settlement to support the sustainable investment goals and related economic goals of LDCs. Thank you.